Hello, everyone. Thank you, everyone, for joining us today. We're so excited to have you all here. We're about to start. We're going to wait 1 more minute so everyone else can join us. If you can, please leave in the chat where you're from and from where you're watching us so we can get to know you better. We're so excited to have you all here, and we're so excited for this webinar. So we have Gaylene Rogers with us today talking about probate and Heirship, primarily for real estate investors. So we expect an amazing webinar. So we encourage you all to write all your questions during the webinar that you may have in the chat box or in the Q&A box. So she's able to answer them as soon as possible. It usually happens at the end of the webinar, so feel free to ask her all the questions there. So we're Real Estate IQ. Your deal is our mission, and we are deal maker and dream maker. And we provide the best real estate solutions, committed to help one more person to win. So make your deals come true. So this is a streamline your deal making process. So these are the solutions that we provide. So we offer off-market leads. We provide daily updated lists, Monday to Friday, of motivated sellers to contact. So get the freshest data mined straight from the card houses. We also offer EDA CMA. So run real estate comes in seconds with our renewed CMA. You can check each property's data, select the ones to compare, and get reports instantly. We also offer you custom leads mining. If you're looking for a specific area leads, look no further. We now provide custom off-market data mining all over 50 states. And we also offer virtual assistants, one solution for administrative tasks, customer service, and technical support to grow your business. Let's work together toward your success. So if you're looking for more, please try our exclusive membership. These are our social media accounts where you can follow us as well. We're in Instagram, Facebook, LinkedIn, and YouTube. And you can use the QR codes that appear on the below of each icon. So you can join us in our community. And you can also use the QR code that appears on the right side of the screen. So you can join us in our newsletter so you don't miss any of our weekly webinars and in-person events. Ricky is asking you, sorry, I interrupting because Ricky's asking if this presentation is for agent or for buyer. I guess, Gaylene, this question
it could apply.
Is for you.
It could apply to either one. It could apply to either one. It's a little more geared towards the investor, but it certainly could apply to, the agents as well.
Perfect. Thank you for answering. And great to have questions from the beginning.
Yeah.
Moving on. We offer you a free 30-minute in-depth consultation of real estate IQ services with one of our experts. So feel free to schedule it now by scanning the QR code that appears on the screen, or also by contacting Bracenet at realestateIQ.com. And this is a very short video of what we do. Okay, so I don't want to make you this more time. Thank you again, everyone, for attending. I will stop sharing my screen and we're gonna move forward. Gaylene.
Oh, I'm sorry. Hi, okay, I'm sorry.
I'm so sorry.
Yeah, thank you, Maria. Um,
Thank
as
you very much.
So as Maria said, I'm Gaylene Rogers Lonergan, and I'm a real estate lawyer, been one for quite some time, and I hate to say it, 40 years. And during that, about 24 years ago, I started my firm, Lonergan Law Firm, and shortly thereafter, I was introduced to some investors, and I knew what they were doing, and they understood that I knew what they were doing, and so my business grew with investors, and now it accounts for about 75% of my business at least. So I also run a title office. I'm an office of the title company. And I close a lot of investor transactions. And as part of doing that, we kept running into titles where someone that was in title had died. And it just became, because those are prime deals for investors. Generally, heirs want to sell fast. And those are very lucrative deals for you guys. So we have kind of developed an expertise over here on doing that. And so I'm going to try to share some of my knowledge that I've gained from doing that um, uh, uh, with you all. Okay. I'm sorry, it's been a day or two since I've done a webinar. I used to do them all the time, so bear with me, okay? Okay. Let's see. Okay, let's launch right in. We're going to talk about probate and heirship, a primer for real estate investors. But like I just answered the question of the agents need to know this kind of stuff too. So I think it would work just as well for them. And I threw in a few drawings, cartoons. This is one to start with. It says, I'm a performance piece entitled The Probate Experience. It's kind of like that. It can be torturous. It doesn't have to be, but it can be. Okay. Oh, here we go. Oh, a little bit about me. It's pretty boring. I've been around a long time. I'm a Texas Tech Red Raider. I'm a Patrick Mahomes fan as a result. Go Chiefs in the Super Bowl. And I've worked in a big firm doing commercial real estate. I've worked in a big bank doing commercial retail development. I've worked in a big title company doing closing and underwriting. So when I decided to start my own firm, I kind of had a background across all areas of real estate. I'm going to put my glasses on so I can see a little bit better here. Okay. All right. I just wanted to let you guys know that even the super wealthy don't necessarily take care of their business as they should before they die. This has been a couple of years now, but turns out that Prince, when he died, had no will. And boy, what did that open? Just opened a huge can of worms, people fighting over his assets, supposed children coming out of the woodwork, brother and sister coming out of the woodwork. And I don't know that estate has even yet been settled. But it's just an example of what you guys are going to be dealing with your clients that you're trying to buy properties from. So, what is probate? It's generally defined in Wikipedia and elsewhere as the legal process of as the legal process of administering the estate of a deceased person. It resolves all claims against the estate, and it distributes the deceased person's property. In this presentation, we're going to include not only the legal process of validating a will, but we'll also include dealing with heirship, such as the process of disposing and transferring property of a deceased person who either died without executing a valid will, and that's legally, that person is called an intestate, or whose will was not timely submitted to the legal process of probate. I don't know how many of you on this webinar have ever come across this situation. Some granddaughter wants to sell a property that her grandparents owned. And maybe grandpa, who was the last to die, had a will, but they never took it to the court to have a court of law validated. And you only have 4 years from the time the person dies in order to take it to court and get it validated. If more than 4 years has evolved, it's as if there was no will, and the person that died becomes, at that point in time, an intestate. Okay, so why invest in probate and heirship properties? It can be one of the most lucrative niches in real estate investing for various reasons. The statistics show that 80% of all the properties left to the family get sold generally within 1 year. So it's a lucrative, it's a open market. Most people who inherit property almost always want to sell. They don't want to live in that property. They probably live in different parts of the country. They just want to get rid of it, okay? Which that's where you guys come in. And they generally don't want to spend any money to make the properties attractive to retail buyers, and therefore are more willing to sell at a lower wholesale price. The negatives are that it can be very time consuming quite often, and that's going to depend on the family situation. If someone died without a will and they only had one heir, that's going to be able to be done pretty quickly as long as that heir wants to sell. But that's not the kind of deals I usually run into. I run into the ones where there's usually 3, 4, 5, even more heirs. And you have to deal with all of them. All of them have to be willing to sell. So you're dealing with multiple sellers, and more importantly, you're dealing with emotional issues between family members. You know, there's all kinds of family squabbles, and they come out when there's money involved. I'm telling you, I'm dealing with one right now. Everybody, been trying to close a deal for about a couple of months now. Did affidavits of heirship, which we're going to talk about in a little bit, and there's five sellers. Everybody's ready to go except one. And she's kind of put her foot on the brake, and we're just having to wait to see if all of our hard work is going to pay off, whether she's going to join in or not. And the emotional issues also involve emotional attachment. If it's the house that the heirs grew up in, a lot of times they have very emotional attachments to the property. I don't know how many of you guys are in the Dallas area, but there is an investor that runs commercials quite frequently that what he says is we make sure we deal with the heirs' emotional issues, and then he has the kids come on and say, oh yes, he knew exactly how we felt, and blah 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 blah. Okay, so I've had a closing where one of the sellers sat there and cried the entire hour she was in my office because it was a very emotional situation for her. So you kind of have to become more like a social worker than a real estate investor. I do a lot of that. I do a lot of that hand holding with people, and you guys will have to do that as well. But it does pay off in the long run. Then there's often, almost always, quite frankly, title issues can be quite common and have to be resolved before the property can be sold. Again, I have another file that I'm working on right now. When we ran the title, which I already had a general idea what I was going to find, but when we ran the title, we found 10 judgment liens against the property. We found taxes. We found deeds of trust that had to be paid off. We found a list pendant filed against the property, and we found a contract, a affidavit of contract, memorandum of contract that had to be dealt with. So quite frequently there's a lot of issues that a title company has to resolve, and you want to make sure you're dealing with a title company that knows how to deal with those type issues, because trust me, not everybody does. Here's another cartoon I found. It's there at the lawyer's office reading the will, and the heirs say, well, on the face of it, it sounds great that she left me her house, but it's gone stale, and what Hansel and Gretel didn't eat, the birds got the rest of it. So how to find these leads? Of course, real estate attorneys and title attorneys are one source, one good source. I almost always, when a deal like that falls in my lap, I farm it out to one of my clients. And that happens quite frequently. Accountants or other professional executors, again, they have clients that someone has passed in their family, and the accountants or the other professional executors are in a position to refer the heirs to someone to buy the house. Wills and estates attorneys, same thing. They I know a lot of investors partner with them, and they sell their properties. The attorney gets it set up so that the property will be sold to a particular investor. Now, there's commercially produced lists. I don't know. I'm not trying to push the Roddy probate report, to be perfectly honest. I don't know that it's still called that. I know there's several commercial produced lists that can give you, it can give you a listing of all the probates that have been filed in a particular county. All right. It doesn't provide you with any information about people that died without a will, but at least as far as the people that had a will and their heirs took it to court to get it probated, that's a good list. Believe it or not, newspaper obituaries. I used to deal with a woman who called herself the wholesale diva, and she scoured the obituaries, particularly on Sundays, and then went and did her research to see about properties, and then would approach somebody about it. And I know there's other means, and you guys may have other suggestions. And when we get to the end, if you do, please share those. Okay, let's see. So how to market to the estate and the heirs. Very similar to other wholesaling techniques. You tell them you can close quick, pay all the fees, and buy it in a cash transaction. Now, I want to warn you about what I just said there about pay all the fees. I would make sure you say pay all the normal and customary fees, okay? We have to prepare a lot of documentation when there's no will that we charge for, particularly affidavits of heirship, deeds from the various heirs. If there's a lot of heirs, that can add up. Getting certified copies of a probate that's already been done, recording those things. Those are not normal and customary fees, and generally you may not want to pick those fees up. So you have to be careful about in your contracts and in your marketing that if you don't want to pick all those up, then you need to qualify it somewhat. And the other, it can be, like I said before, it can be a very emotional transaction for the heirs. And you just essentially hold their hands. Okay. You hold their hands and show them concern and show them that you care about their issues. And then you could also offer assistance with resolution of legal issues involved with property transfer. And so that an attorney that can help with that, and they would be mostly appreciative of that if you are able to provide that to them. Okay, so let's just dig into it. The buying process, the laws that are affecting probate and heirship purchases. Okay, the first and foremost source of what governs everything is the Texas Estates Code. It became effective January 1st, 2014. It governs all things regarding the transfer of deceased individuals' property in Texas, whether through the validation of a will by the court or through intestacy with a will or without proving a will. Okay, so if they had a will and they want to probate it and it's still within the 4-year statute of limitations, this is the procedure. The original, we have to have the original executed will needs to be submitted to the probate court in the county where the individual died. And that if they were just visiting, it's still in the county where they died, not where they lived. Okay. Together with a legal petition to have the court approve the will. So essentially, the executor is just filing a lawsuit. It's just with a particular specialized court, the probate court, for a specialized reason to get the will approved. Okay. So you have to prepare that lawsuit, you have to file it. And then once that will and the application to submit it to probate is submitted to the court, then a hearing date gets set, and generally it's 30 days out, particularly in Dallas County. Now, if you're dealing with some smaller counties around here, it might be quicker, but don't count on it being less than 30 days. Then you go to the hearing with the executor. The executor and the attorney appear at the hearing. And the executor provides oral testimony as to the specifics of the will. Whenever I probate a will, which I do a lot of those, I have a series of questions that I ask the executor about the person that died, when they died, how old they were, where they died, were they, some other issues, were they married? Did they have any children? And we run all through all of that. Then when we're finished, I rest until the court, we have submitted everything we have. And then following that, the probate court judge either says, I accept this will, which is what happens most of the time, or they accept this will and have its clerk issue what's called letters testamentary to the executor. Those are documents that authorize the executor to act under the will, including the power to sell the property. Now, I have had instances, as have a lot of people, had instances where the court does not approve the will. I had one just not too long ago where it was a deathbed will, and the probate, the estates code provides that you can have a will that there is no notaries as long as no witnesses, as long as the will is written out in the deceased's own handwriting. Well, these people that were trying to get us to probate this will, they, I guess, felt like the deceased handwriting wasn't good enough, and they typed it up. Well, under Texas law, you cannot probate a will with no witnesses, and their signatures notarized, unless it's handwritten. If it's typed up, the judge is not going to approve it. So as a result, we had to go back and open what's called a proceeding for independent administration, which is what can happen when there's no will. So you can also submit a will only as a muniment of title, and that's I call it a short form type of probate. And that comes to play when really the deceased had nothing except the real property. If that's the case, then you can apply for a muniment of title, and essentially it's a short form hearing. The judge, if he approves it, issues an order, and that acts as title, allowing the executor to transfer the property. So once all of this is done, in order for a title company to be able to close, based upon the executor and or the beneficiary under the will signing the documents, we have to get a certified copy of the probate application and the will recorded in the real property records where the county is located, in the county where the property is located, to establish ownership in the beneficiary. Now, without a will, that's a little trickier. That is a little trickier. You don't have to go to court if the person does not have a will. It is an option. You can open what's called a probate to determine heirship, but you don't have to. The Texas Estates Code specifically sets out who the heirs of a deceased individual are based upon the family situation of the deceased and the nature of the property, whether it's separate or community. If you look in a section in the descent and distribution section of the Texas Estates Code, it lays out all of the different possible scenarios. And let me back up a little bit and tell you that in the price range of homes, probably up to about 200,000 now, you're going to find that probably 95% of the people who own those homes did not have a will. So you're going to be dealing with this situation predominantly. Okay. So under the Estates Code, it says, I'm going to run through some of the scenarios. If the deceased was married with children, all from the same marriage, that is the key provision, all from the same marriage. As to their community property, it all goes to the surviving spouse. You don't have to deal with any children. If it's separate property, 2/3 of the deceased property goes to the children, and 1/3 to the surviving spouse as a life estate. Once the surviving spouse dies, then that 1/3 reverts to the children. If they're married with children and any of the children are not from the current marriage, this is where it gets really sticky. If it's community property, the surviving spouse obviously retains their 1/2 interest in the property, but the other 1/2 of the deceased goes to all of the deceased children, ones of the current marriage as well as ones of a prior marriage. And you don't know how often we bring that up, and people don't even know anything about this family, doesn't even know anything about the previous family. So you have to do a lot of research to find them and to get them to join in to a sale of the property. That's another very good reason. If there's a mixed marriage, anybody should have a will, because if they don't, they're going to leave a possible horrendous situation to their heirs. As far as separate property, it's the same as if all are from the same marriage. 2/3 of it goes to all of the children, and 1/3, the surviving spouse gets a 1/3 life estate. When that surviving spouse dies, the other 1/3 goes to the children. This is important because you need to know who you need to deal with when you're trying to buy the property. Now, if they're married but they don't have any children, only their parents are surviving. All right. If it's community property, it all goes to the surviving spouse. But if it's separate property, 1/4 goes to the father, 1/4 goes to the mother, and 1/2 to the surviving spouse. So if they're married with no children, if they're unmarried with no children, it gets kind of complicated. The general order is first goes to the father and mother, then goes to the brothers and sisters. Now, if there's only a father or there's only a mother, then the surviving parent shares with the brothers and sisters. And then if there's none of those, then half of it goes to the paternal kindred. Now we're talking about cousins, aunts, uncles, and 1/2 to the maternal kindred. Now, I had a deal back when I first started with my firm that I had a hard money lender that I closed all his deals. And he called me one day and said, "Hey, I need to get title. We need to close on this deal really fast." This investor came to me and said he had bought a property and he wanted to cash it out. So I said, "Okay, we'll open the title." So we got the title back in a day. Well, when the title came back, it showed his name in title together with all of the unknown heirs of the deceased. And come to find out, the deceased didn't have any children, didn't have any spouse, but he had about 20 cousins. And what had happened is one of the cousins had signed an affidavit of heirship saying that they were the only heir. And this investor accepted it. He didn't go to a title company to close the transaction. He took that woman's word for it, and she fleeced him for his money. And I had to explain to him that he was going to have to get all of these 20 cousins to agree, and he was going to have to pay them, I was sure, again, even though he paid that one girl, in order for them to deed their interest in the property over to him. So I never closed that loan for some reason. Now, if they're unmarried with children, it all goes to the children, equally divided. No spouse, all goes to the children. And also you need to be aware that just because a brother or sister or child is deceased before the deceased that owns the property, their children take their parents' share. So I have a deal I'm working right now. I've been working it for over a year, probably almost 2 years, that 3 siblings, they're all elderly. They're all in their 80s, at least. 3 siblings had purchased a property, and only one of them had any children. And so when they died, then the ones that didn't have any children, their interest went to their siblings, even the ones that predeceased them. And there were 16 siblings. So each one of that deceased siblings' children shared and had to sign. And we had to do affidavits of heirship for something like 12 individuals to get to the bottom of who actually had the authority to sell the property. Okay, so here's another cartoon. So this is at the probate court. And one of the siblings says, well, he's a bastard and barely knew our father. And the judge says, well, okay, we have a family reunion here. Just like a family reunion. Okay, now the documents you need for intestate succession. We already went over the documents that you would need if there was a will and it was probated. That what documents you would need to get to the title company so they could close the transaction. Now, if there is no will, these are the documents you're going to need. First, you need a copy of the death certificate of the deceased. I put on here certified, but I accept non-certified copies. I do like to get original of it, but I don't always get it. And that's to establish that the person actually died. Okay. And it also provides a lot of information: when they were born, when they died, where they lived when they died, whether they were married, what their parents' name was, of course, what they died from, but we don't care so much about that. But it gives you a lot of information that's going to be needed in order to be able to do the documentation necessary to transfer the property. The key document is the affidavit of heirship. This is an affidavit that gets signed by a family member that states the facts regarding the life of the deceased, such as when they were born, when and to whom they were married, how many children they had, and the information about the children. In addition, statements as to whether there are any debts of the deceased outstanding that would have to be paid. And it's usually prepared by the title company. We prepare so many affidavits of heirship. I mean, we are constant. Most people in my office, we're working on affidavits of heirship. Okay, now, in order for the affidavit of heirship to be sufficient for a title company to insure it, you've got to have two independent, non-related third parties who knew the deceased, and preferably for at least 20 years, who have to corroborate the statements in the affidavit being made by the family member. Neighbors are a great source, longtime friends. And again, the idea is that they need to know them for about 20 years, because that way they would know whether they had children, who they were married to, whether they were married multiple times. I had a transaction several years ago where the heir came in and said, I told him he had to do affidavits of heirship, and he brought the man, the deceased, had been dead for about 15 years. And so the guy brought in a gentleman that was about, I think he was 18 years old. So he was 3 years old when the deceased passed away. And I said, I'm so sorry, but that's not going to work. There's no way this young gentleman knew anything about this deceased. Okay. So you got to have people that know what they're talking about, and it can't be family members. I know a lot of people want to do that. Now, I will say occasionally there are exceptions. If someone died 30 years ago and there's no one left that knew that person, it may be possible to only get one, and they might be some distantly related relative. Okay, but that's the exception rather than the rule. So we give the heirs questionnaires for them to complete, filling in all the information about the deceased, when they were born, where, who they're married to, when, name of their children, when they were born, if any are dead, and things such as that. Then when they get that put together, then that's when we take that questionnaire and create the affidavit of heirship. I regularly have people come back to me and tell me, hey, we don't know. So they think they can just leave it blank and they can still sell the property. It doesn't work that way. You have to have complete information. So what our office does, and quite frequently does, is we have software. We have skip tracing software. We have Ancestry. We have genealogy software. We have all kinds of software that we might be able to help fill in the blanks on some of that information. As long as we feel like it can be verified, then we will help do that. And then once all the affidavit of heirship is done, it should show us, based upon the Texas Estates Code, who are the legal heirs of that deceased person, based upon whether it was community, separate, they had children, they didn't have children, all of that. So once we determine who all the legal heirs are, then we have to get deeds from those people. And we are, like I think I mentioned earlier, I'm working on one right now where one heir is holding things up. Everyone else executed all their documents and she's holding it up. So once we know who all, this is also something you really need to pay attention to. Once we know who all these legal heirs are, then the title company must search their name for out liens, judgments, issues, child support, judgments, credit card judgments, taxes. Trying to think of other examples. If any of those pop up, then those have to be paid or released. So generally, the child support people will take whatever amount that the heir that has the child support lien has, as opposed to all the money. And sometimes they won't even take all the money. Judgment liens, if it was a homestead property, well, it wouldn't be homestead of the heirs. So that, let me back up on that. Judgment liens, we have to talk to those judgment creditors and get a payoff, see if they're willing to accept any kind of a reduced settlement. If they're not, then those judgment creditors have to be paid so that they will sign a release. So if there's a lot of heirs, that can get pretty involved. But just be aware of that. That's after the affidavit and the heirs are determined, that's the next step before you can close. Okay, now let's talk about some other issues that might prop up with probate and intestacy, and that would be MERP, Medicaid Estate Recovery Program. Since 2005, by law, Medicaid can make a claim against the estate of a deceased Medicaid recipient for covered Medicaid long-term care services. Okay, this is when mama or grandma or papa go to a nursing home and don't have the money to pay for it. You can get Medicaid under the law to pay for it. But if they do, they are going to have essentially an unrecorded lien against the property, with a few exceptions. Okay. First of all, the person has to be at least age 55 or older at the time the services were received. And they must have applied for covered Medicaid long-term care services on or after March 1, 2005. If those two don't comply, then Medicaid can't make a claim. So that's one of the things we ask right off the bat. Did your mama, daddy, grandpa, did they receive any Medicaid payments? If they say yes, or if we suspect that they did, we send a certification to Medicaid as the title company for completion as to whether Medicaid is intending to make a claim and in what amount. It usually takes about 10 days from the time we submit it to them to get it back. The heir has to sign the certification, and then we, the title company, send it to Medicaid. Then they give 10 days later, they come back and they tell us, yes, we're going to make a claim for $50,000. Well, sometimes the property is not even worth $50,000. So then you start looking for exceptions from the claims so that, you can sell the property. I did that one time for an investor client of mine. And luckily, we fell into one of the exceptions. And so Medicaid waived their claim. So if there is a surviving spouse or a surviving child under 21, or a surviving child of any age who is blind or permanently disabled, they will waive their claim. If the value of the estate is $10,000 or less, or the Medicaid claim is $3,000 or less, they will waive their claim. This is the one that saved the deal I was doing. There is an unmarried child residing continuously in the homestead for at least 1 year before the time of the recipient's death. So the person that was trying to sell the house had been taking care of her mother for, I believe it was 5 years. Okay. The mother had received Medicaid proceeds, Medicaid benefits, however. So they waived their claim against her. And she was able to sell the house free and clear. And then another exception would be if the cost of the sale of the property would be equal to or greater than the value of the property. So in other words, there's no proceeds. There's no proceeds. How nice of them to waive that. Another little cartoon, the body's not even cold. The widow is standing there, and here's Uncle Sam. I'm here to recoup my Medicaid payments. It's not quite that quick, but they do make claims. And so then I wanted to give you some final thoughts on this whole subject. This one says, I should tell you that your uncle's will may be contentious. A codicil insists that it be read on Jerry Springer. So there might be some chairs being thrown among heirs or whatnot. But it may sound daunting, but if you're dealing with professionals that know how to handle these type situations, these type heirship situations, it can be successful. The main thing I would tell you is that you have to have patience. You have to have patience because it's not a straight line thing. We try to get information from people. They give us certain information. That means we need information about somebody else. And so you just can't get frustrated. You just have to realize that all of that has to be worked out, or there could be a title problem down the road, and nobody wants that. Okay. So if you do have any questions, we can talk about them right now, or you can contact me at my firm, Lonergan Law Firm. I'm right here at the High Five on the southwest side of the interchange between 635 and 75. We're right here in the lobby. It's a beautiful building, and we can help you. We can help you with your issues on that. I think that is the last slide. And so let's see, I guess I should stop sharing and we'll see if Maria is there. Oh, here's a chat. Let me look at the chat. Hold on. Come on, let's see. Let me go up. Let me go up to the top. Okay. The first question I answered right off the bat, is this for agents or buyers? It would apply to both. Now, what are examples? Justin Montoya asked, what are examples of separate property? Okay, say the couple was married, but one of them, their parent died and left them a piece of property. That's the child's separate property. If someone owned a property before they married, that's their separate property. Okay. If there's a prenuptial agreement that any certain property acquired in a certain way is going to be separate property, then it would be separate property. Give you a real life example. I purchased my home back in 1992 here in North Dallas, and I was not married at the time. I got married a couple of years later in 94. That property was my separate property. Now, my husband, even though he had no ownership interest in my property, under Texas law, he was my spouse. That was his home. That was his homestead. So he had certain rights as under homestead. That dates back all the way back to the Republic of Texas. Back when we were Wild West, Dad would go to the saloon, get drunk, start playing poker. Okay, runs out of money. All he's got is the title to his house. He puts it up for his bets and he loses. Then guess what? The person that won it goes out and tries to kick off mom and the kids. So the Republic of Texas said, no, we're not going to allow that. Nobody can sell, mortgage their property if it's someone else's homestead without them joining in, even if they don't own the property. Okay, it seems like most would be community property and go to the spouse, wouldn't it? Well, I went through all of that. If it is community property and they bought it when they were married together, yes, it should be community property. And as long as there are no children from another marriage, no children of the deceased from another marriage, which, that's not uncommon. That is not uncommon at all. All right, for there to be children from another marriage. So if there's no children from another marriage and it's community property, yes, it's all going to go to the spouse. But otherwise, it's not all going to go to the spouse. So Fred, hi Fred, great to hear from you again. He wants me to define community versus separate property. Well, I pretty much just did. Community property is property that you acquire during your marriage, that you acquire together during your marriage, okay? Anything you earn is community property. Anything that you acquire is community property. If you inherit something, that's separate property. If you owned it before marriage, that's separate property. So let's see, Justin Montoya helped me out here and said, first, community property refers to any property that was acquired during the marriage while living in a community property state. Oh, thank you for that. Absolutely. We live in Texas, California. I'm trying to think, there's a few more states, but not a lot, that recognizes community property. In the others, that's because it's based upon a Spanish law. But in the English law states, there is no such thing as community property. That's why there's a lot more often there's alimony and that sort of thing. And then Justin goes on to say, separate property refers to property owned before or after marriage or property that was never shared by the spouses. That is correct. And let me give you another example, because I ended up deeding 50% of my property to my husband after we were married. Did that make it community property? No. What that made it was my 50% was my separate property, and his 50% was his separate property. Let's see. So, hi, Ryan. It's good to see you. Mr. T.O. Birdwell, good to see you. Andrew Dale is asking if you can get a copy of the presentation at the end. So what will happen is Maria is going to, after we're finished, she's going to give me a list of you all with your email addresses, and I will email all of you a copy of the presentation. It probably won't be today, it won't be tonight, and it may not be tomorrow, but by sometime early next week, you guys will get an email of the presentation. Lisa Simmons asked, what do you mean by deeds from all legal heirs must be executed? Okay, so if someone's wanting to sell a property, usually I get involved in this situation where one of the heirs or all of the heirs are wanting to sell the property to a third party. All I'm saying there is all of the heirs have to sign a deed to the buyer. It has to be 100% of the heirs. Okay. Now, sometimes what the heirs do is they agree amongst themselves. There's no animosity between them, so they deed everything. The other heirs deed their interest to one of the heirs, and then he's the seller on the property, and then he divvies up the proceeds once the property is sold. Oh gosh, now you're Carolyn Cantrell wants to know if student loans would be paid out of probate. If the person is deceased and has student loans, yes, I would say yes, the student loan lender would make a claim in the probate, and it would have to be paid out of the proceeds before anything went to any of the beneficiaries. All the debts have to be cleared. T.L. Birdwell asked if Medicaid is different than Medicare. Absolutely. Absolutely. I'm on Medicare. Anyone 65 and older is eligible for Medicare. So I've been on Medicare for about a year and a half. That is one of the great, I don't want to get on my soapbox, but Medicare is one of the greatest benefits that the government has ever given us. It's the best insurance you can get. Medicaid, and you just pay a small premium to Medicare for your basic coverage, and then you can get additional coverage and whatnot. Medicaid is processed through the states. The states are the ones that fund Medicaid, and it's for people that cannot afford, number one, they can't afford health insurance. So they're eligible to get health insurance paid for by the state through Medicaid. And again, as far as elderly people, Medicaid was expanded some time ago to include making payments to nursing homes, assisted living, that sort of thing. So those are totally separate. You can, however, receive Medicaid and Medicare. I don't know if you see all those advertisements from those Medicare salesmen or not, but some of them say, if you're on both Medicaid and Medicare, we can do this for you. So, all right. Lisa Simmons asks, does your law firm work with creditors to reduce the liens and judgments, or does the buyer do that? Our law firm works on all that. In fact, on this deal I'm doing right now, there were 12 judgment liens. And I worked with the heir to, and it was a homestead. It was a homestead property. And if it's a homestead property, judgment creditors under the Texas Constitution are not, those liens are not valid. But title companies don't take the risk of whether that's a homestead or not. So most title companies, including mine, require you to get a release of those liens. And sometimes the creditors don't want to release them, even though legally they're really required to. So the Texas legislature, in fact, I'm going to hope to do a webinar on this topic sometime in the near future. The Texas legislature passed a provision that's in the Texas Property Code where a homestead owner can essentially release their own judgment liens against their homestead. It's about a 30-day process. You have to notify the creditors. But once you've worked through the whole process, then you can record what you've done. It has to be it's very specific. Record what you've done, and then the title companies will recognize that as a release of lien. But yes, we try to clear everything we can. I just want to explain to you the difference between my office and other, what they call fee attorneys' offices, versus a company-owned office where Chicago Title, they're all direct employees of Chicago Title. Everyone in my office is an employee of me. We just have essentially a contract with a underwriter or an agency to close transactions for them, and they pay me a percentage to do that. So I don't get paid, and my employees don't get paid unless the transactions close. So we are highly motivated to help clear any liens against the property so that the transaction can close. So yes, and we have developed a expertise for that over the last 24 years. So we would love to help any of you with that. T.L. Birdwell asks, I am currently under contract to purchase a home currently in probate. The contract was signed with the executor prior to the probate being filed. How do I file a memorandum affidavit of agreement contract? Well, I suppose you could do that. I suppose you could file a memorandum of contract or affidavit of contract in the real property records. But I'll just tell you whether that's gonna be valid or not is gonna depend on what happens in the probate court. Because if the executor is found to not be able to sell the property based upon something in the will or otherwise, then that memorandum is not valid. Okay. So you could file a memorandum in the real property records, but just be aware that it's not foolproof. Oops, I skipped down too far. Here we go. Ryan Gore asks, I tend to come across sellers that may not have enough money to file a probate. Does your office allow attorneys to get paid at closing? Yes, we do. All that I absolutely require is that the filing fees and any process service fees, any out-of-pocket fees that I have to be paid up front, because I'm not going to recoup that if probate doesn't go through. Other than that, I will allow the rest of the fees to be collected at the closing. Does your office handle probate? I'm about to sneeze, so y'all forgive me. Does my office handle probate? There we go. Outside of Dallas and Tarrant County? Yes, we can do it anywhere in the state of Texas. And I have done it anywhere in the state of Texas. The fee might be a little bit higher because it potentially involves some traveling. Courts are getting pretty good about letting us attend hearings by remote, but they're not always. And then what is the probate citations? Well, I'm just saying, on the probate, once we file it, actually, we have to post, there's nobody to serve, but we have to post notices in the public records, in newspapers and whatnot, to alert creditors that we're having, that someone's will is being probated and they need to file their claims. That's what I meant by the citations. Okay, let's see, Mr. Bird, let's see, E.L. Birdwell, let's see what. Okay, he said, they say separate property can easily and often does become community property if community funds have been commingled with the separate property. Well, yeah, that's yes, that is yes and no. I don't 100% agree with that. The community estate could have, because it's hard to commingle a house, okay? It's hard to commingle real estate. But having said that, the community would have a claim against the separate estate for half of mortgage payments, half of taxes, half of the renovation costs. So I don't know that it will that would change the character of the property, but it could result in a claim. And Ricky Shaw, I really appreciate the thank you. And Ryan, I appreciate the good words. And yes, I am going to teach more classes. I used to teach them all the time pre-pandemic. Then the pandemic came along and everything kind of changed. And I got a little bit lazy, and opportunities didn't crop up as frequently, but I'm back in it and we'll be doing more. And once we get your email address, we'll put you on our mailing list so that you'll get notification when I do the next one. Now, have you come across personal property such as mobile homes? Yes. Yes. And mobile homes are kind of a unique animal. They're not real property, but they're personal property, but they're handled a certain special way. That's all I really can tell you without really diving deep into it. Wow. So does the government recoup Medicare payments? No. Medicare, there's no recoupment. That's yours. You paid it. You paid it your entire working life. They don't recoup anything from you other than if they if you make too much money, they will tax you on part of your Medicare payments. But no, they don't get anything from the estate. How can we Ryan, how can we as investors bring value to you and your law firm? Well, I would love to establish a relationship with you. I can help in a lot of different ways, and I would like to establish a relationship, and I would like to be your preferred title company. That's how I try to set up where everybody has a win-win. I don't charge for phone calls as long as they're not day-long phone calls. I don't charge for a lot of things. If I have to draft something for you, I do charge you for that. I do charge for initial consultation if there's an issue. If it's just a meet and greet, I don't charge for that. But as long as it's a win-win, you're bringing your title deals to me. I'm helping you. That's what really brings value to me. And I love being involved in people's businesses, helping them be successful in their businesses. Okay, what if there are no known heirs? Is there a way to buy the property? I ran across a house that I wanted to buy where the boyfriend, age 70, said his deceased girlfriend had no children, no siblings, no parents, no known heirs. Yeah, that's a sticky one. Well, first of all, we need to do a little research to make sure that what he's telling you is the truth. And there are ways to do that. Okay. Like I said, you can look at the death certificate. There's ways you can investigate that. If there truly are no heirs, that could be a problem as far as being able to buy the house. That's something I'd have to talk to you about individually. It could be a problem. Those are called zombie houses. Okay. You might be able to buy them. I've helped people in those situations where the property you can encourage, if the property goes up for sale for taxes or something like that, there might be a way. Ryan, I appreciate the good words. Can I talk about when a partition would be used? Yeah, that comes into play sometimes. I'm having to do a few of those right now. If you just cannot get an heir to sign off on the sale, then you have to, the next recourse is to go file a partition lawsuit. And it's just a lawsuit, okay? And you have to serve all of the other heirs. And essentially, it's the expensive way to do it. It's the expensive way to be able to sell the property, because in a partition suit, generally the judge will appoint a receiver. Okay, a receiver who will market the property and who is in control of selling the property. And receivers are not cheap. Okay, they have their fees. And so that just takes away from the proceeds from the house, right? But then the receiver determines what the value is, what it should be sold for, and the receiver has the authority to sell it. And once it's sold, then the title company divvies out the proceeds. It's not the most, I think that may be the last one. Okay, so I really appreciate you guys. I appreciate your good words, and I appreciate you listening to me. I try to make it interesting. Believe me, I could tell horror story after horror story after horror story. But I try to limit it. But anyway, we would love to see all of you. And like I said, once I get your email addresses, I will send you a copy of the presentation. So I guess I'm going to turn it back over to the host. Oops. Oh, wait. Okay. Well, Ryan, okay, Ryan's got another question. Let's see. Off topic. What's the key to marriage? Okay, you're asking the wrong person there. You're asking the definitely wrong person there. I was married for 28 years. My husband passed away about 3 years ago. But I wouldn't presume to tell you what the key to marriage is. And then someone else asked, is there a percentage that don't close? And I hate to admit it, but there are some that don't close. But I try to give it my all. My assistants sometimes will say, Gaylene, is it really worth this to go into this? And I'm like, well, let's give it a try. I'm working on one right now that I ultimately ended up having to do a partition. The deceased was from the Philippines, lived in Dallas, but most of the heirs are in the Philippines. And I had to serve one heir in the Philippines because she wouldn't join in. So it depends on who's working on it for you. I try to close all of them that I can. Some of them are just, I had a guy several years ago that he wanted to sell this little hunting cabin over on Lake Tawakoni, and that there was no will for his mother. And so I started asking questions. He said, yeah, I have a sister. And I said, okay, she's going to have to sign also. And he said, oh, I haven't seen her since the Vietnam War. So I said, okay. And so I talked to the investor was a client of mine. And I said, listen, what you could do is it wasn't that much money. Okay. I said, what you could do is you could buy it. And if you want a lake cottage, you can buy it, hold on to it for 10 years, and then we'll file a adverse possession and you can get the title, and then you can sell it at that point if you want to. So if you can't find all the heirs, we got to find all the heirs. I mean, we gotta at least know who they are. If we can't find them, that might be one that can't close, but, anyway, you, we can't, the title companies cannot insure it. If you can't find the heirs, then you might have to go to probate court and get a dependent administration and see if the probate court would order the sale. That's all I can think of there. Well, I appreciate it. I would love to write a book. So I've really enjoyed it. You guys have a great evening, and I'll see you soon. Let's see.
Thank you very, very much. It was an amazing webinar. We expecting future webinars, and we hope you like it as much as we did. Thank you so much. Have a wonderful evening.
Thank you.
Thank you. Thank you. Bye-bye.
All right.